Good morning, ladies and gentlemen, and a warm welcome to our webinar that we are providing and doing today together, Eqs Group, with our colleagues and partners from KPMG Law. So this is actually a repeated webinar that was originally planned last week. So some of you will have been registered last week and have seen that we were running into some technical issues that forced us to postpone to today. So apologies on the one hand for this once again, and even better to see that so many of you were able to just join today as well, even if it was quite a short-term notice to go to this Wednesday. So this webinar will cover one of the probably mostly discussed topics around the EU Whistleblowing Directive, which is about centralized or decentralized setup of whistleblowing schemes, whistleblowing systems, and what do I do if I'm a larger company group, actually? So what am I supposed to do, and how do I structure and set up the system? So this is what we will discuss today. Maybe a very few logistical hints in the beginning. First thing is, whenever you require support, just let us know. Use the chat function, and our colleagues in the background will try to help you. As well, if you have any questions to the speakers, to our experts in this webinar, just put them in the chat. So we will see them, we will prioritize them, and then either try to here and there put them in between for an answer, or at least keep them for the FAQ Q&A session in the end of the webinar. Who will be the speakers and the experts for you today? Warm welcome to Bernd Federmann from KPMG Law and his team and the colleagues. I'm sure they will introduce themselves quickly later on when they have their speaking part. But I think we again have really great experts that will be able to provide a lot of valuable information around the topic to you and get some of your questions answered. So, by the way, questions. We would like to again start with a short poll question, just to understand where all of you are. So you should be able to now see on your screen the question that we would like to ask all of you. So just to understand how your whistleblowing system is currently equipped and set up, if you have one in place. So are you running a purely centralized system? Then choose the first option, exclusively central. Are you doing this very decentralized and have it in each and every of your entities? Choose the second option. If it's a mix of both, option 3 might be the right one. And just in case that someone does not yet have a whistleblowing solution in place, option number 4 is the one for you. So let's give this maybe half a minute. And thanks in advance for your answers. But this will allow us to put some probably put some more focus on certain aspects depending on what you have and how you are set up. All right. So half of you have already voted. All right, so I would say let's take a look at the results. So I will move on to the next one. So you can then not vote anymore, but let's see what the results are. And from a personal perspective, I must say I'm not surprised to see that more than half of you are running a centralized system. because this is what has evolved over the past years in the market, and how it all started with whistleblowing systems over the years. Interesting enough, a small portion, nearly 4%, obviously having a purely decentralized system, and then maybe a quarter of the answers roughly with a mix of both. This is also something that we've seen in the market and amongst our customers in the past years, that there might be a centralized system, but for certain markets, certain entities, an additional decentral system is. And for the 17% not having any whistleblowing system in place, I think the recommendation is quite clear, especially with now the German draft being out as well, and more member states taking up the EU directive to further look into this and get prepared, because even if it's not happening immediately, it will happen anyhow. So yeah, and with this, I would like to hand over to Bernd Federmann from KPMG Law. Bernd, warm welcome. Thanks that you're again joining as speaker, as an expert with your team, and that you will take us through the next part of the webinar. Over to you.
Many thanks, Jens. Yes, and also welcome from my side. More than 55% of you run a only centralized system, so the topic of this webcast might be really of relevance. My name is Bernd Federmann, partner with KPMG Law in Germany. I'm with KPMG since 2007, and I'm focused on compliance advice. With regard to whistleblowing, we are in a good alliance partnership with Eqs Group for holistic solutions. Our KPMG Integrity Service network covers more than 80 KPMG offices and also all the 27 member states. Our topic today: centralization versus decentralization, whistleblowing in a company group setting. First, we will have a look on the position of the EU Commission with regard to the Whistleblowing Directive and the requirements there. Then we will have a look at the member states and their transposition and focus on the new German draft law Jens mentioned. Daniela Scharf, then a colleague of mine, will then focus on the practice examples of experiences of a huge group company and how to manage this requirements in practical aspects. And after these practical implications, Andreas Boksch will highlight the labor law aspects, and Ariane Lof the data privacy aspects we have within group situations. Last but not least, Jens again will take over and give a look and feel how all this might be properly implemented in an IT system solution. So I think we can go to the next slide, please. Thank you. Last summer, the European Commission, as I mentioned before, made 3 statements in June, the 2nd, the 29th, and July the 16th. That was last summer. Statements on the requirements of the design of a whistleblower system within corporate groups. So the opinion was prompted by the Danish draft legislation, and the Commission pursues a decentralized approach and specifically requires a separate system for each legal entity with more than 50 employees. This is irrespective of whether a group-wide system has already been implemented or is planned. Only entities with, which are medium-sized and do not have more than 50 to 249 employees get some help, and they are allowed to use common resources. That also applies to single group companies within a group of companies. However, this requires that still reporting channels exist and remain available at the subsidiary level. It requires that the whistleblowers are clearly informed that the designated department at the corporate headquarters, for example, or sister companies, is authorized to view the report and conduct the necessary investigation. And the whistleblowers, they have the right to refuse this and to force the subsidiary to conduct case handling only at a subsidiary level. And any follow-up action must be taken and feedback must be provided to the whistleblower on the subsidiary level. According to the Commission's comments, the provision of Article 8, subsection 5 of the Directive, the most important article in this respect, cannot help, according to the Commission's position in this respect. Reporting channels can be operated internally in a single company by a person or department designated for the purpose, or can be provided externally by a third party. And the question is, might a group company, another group company, be such a third party? And in the Commission's view, a group company cannot be such a third party within the meaning of the EU directive. The Commission takes this view in particular from the hint number 45 of the directive. Group companies are not listed as possible third parties. Possible third parties are just lawyers or auditors but not group companies, and therefore the position is no group company as third party. That means all group companies must each maintain a whistleblower channel themselves. They must maintain their own impartial case handlers, and they must themselves enable personal meetings with the whistleblower. The Commission clarifies that the directive does not prohibit centralized whistleblowing functions within a group. However, there's only in addition. For cases where the whistleblower does not trust these central channels, it must be possible to report to a only local level where the whistleblower works. Bottom line, centralized whistleblowing channels are seen allowed, however, only in addition to decentralized channels and case handlings in each group company. And only for small companies with less than 50 employees, there is no obligation to set up a whistleblowing system according to the directive. The directive does not apply to these companies. This means that small companies within a corporate group may not need a channel at all and might have a decentral or only a central channel, but that depends also on the transposition in the national laws. Big question is, how do the member states then handle the details in their own laws, and what is the relevance of the Commission's opinion in this regard? So I think we can go to the next slide, please. As you see, the EU directive has not been transposed into national law in all member states. On this map of Europe, you can see the current transposition status. More and more states are implementing it month by month. On May 19th, KPMG and Eqs will hold another webcast on this topic, on the status of transposition. And we invite you also to attend this workshop. We have also produced a white paper on this, and Eqs has also produced a white paper on this, which will also be published next week. There you can read about the transposition status. So we will not go into general detail about the transposition status. Instead, we will focus on the group topics. And I think with this view, it should be enough, and we can go to the next slide, please. Thank you. In Germany, the EU Whistleblowing Directive has not been transposed yet. In 2020, a first draft law of a whistleblower protection law was worked out, but was not officially published as the government could not agree on its content. And since April this year, a new draft of the Federal Ministry of Justice is in the legislative process in Germany. It is expected that the new German law will come into force in autumn this year. At the moment, they are catching for statements of association and so on. And in accordance with the directive and its interpretation by the EU Commission, the draft law allows companies, regardless of whether they belong to a corporate group or not, with up to 249 employees, to set up and operate a joint office for the receipt of hints and the case management. Now, this path is closed, however, to companies with more employees. They can only commission a third party to operate the reporting channel and the case management. According to the narrow interpretation of the EU Commissions, as we heard before, such third party can in principle not be another group company. And that is exactly the point which the German draft law turns open. The German draft law makes it possible to establish a centralized internal reporting channel and one group company in corporate group structures, irrespective of the company size. According to the explanatory notes, not in the main text of the law, but in the explanatory notes of the draft law, it was possible to set up an independent and confidential centralized unit as a third party located at another group company, for example, the parent company. This centralized unit can then also work for several independent group companies via service level agreement. However, the original responsibility for handling and following up an identified violation always remains decentral with the concerned group company, however may be sourced out via service level agreement. Such independent, impartial and confidential reporting offices centrally located within a group, but independent in the sense of the directive. This is regarded as a legally permissible support, such as and it was provided like law firms or other external firms, and then according to the position of the German lawmakers are in line with the directive. Bottom line, centralized operated whistleblowing channels might be a possible option if the draft becomes a law. However, decentralized responsibility of the respective group remains. The big question is, does the Commission see the German draft in line with the directive? And what is about internal group company structures? And about the international group company structures. If you have subsidiaries in different countries, you have to look at the different national laws. By the way, we are asked of the Ministry of Justice to make a statement on this draft law, and we will recommend that the centralization is taken into the original text of the in the main text of the law. That's so far. We can go, I think, to the next slide, please. And that is very short. Here we see some examples already transposed in national laws. The solution in Denmark, that is, here we have a situation like it is in Germany. In France, we have a clear direction to centralization also. Would not be France if it was different. However, to be further outlined through national directives. And Portugal, very strict position similar to the one of the EU Commission, and Sweden similar, but open to the public sector. However, in any case, there might be possible constructions which enable more centralized solution in group structures, a question of drafting intelligence service level agreements and so on. But not only depending on mere whistleblowing laws, we have several further aspects, and we can go to the next slide, please. Thank you. And I don't want to go into detail. You get the slides. However, whistleblowing is important for compliance management as to the provisions given in the US Department of Justice guidance on compliance programs as a hallmark of compliance, also in group structures and other standards. And with regard to the legal corporate group liability, you might be responsible for misconduct in your subsidiaries and thus need to control them and need to be informed also via a whistleblowing system about what's going wrong. Although this is to be taken into regard when implementing. And then, of course, the international regulations, state by state, and also specific requirements with regard to local laws for specific regulated industries like the financial sectors. And further and more on data on focus, we will look at the data protection law, data privacy, what's about the group structures in this respect, and also with regard to labor law. But before we do this on a legal aspect, all these questions are related to the requirements of concrete group business models and business processes. They need a deeper look into the practice of a corporate group. And this is the topic of my colleague Daniela Scharf, and I will hand over now to him.
So yes, thank you, Bernd. Before I start with a deeper look into the practice and what does the new draft of the German law could mean for a corporate group, especially, I would like to briefly introduce myself. My name is Daniela Scharf, and I'm a senior manager at KPMG in the area of risk and compliance services. And I have several years of experiences in the consulting business, as well as working for an international operating company. My focus is on consulting of corporates with respect to all compliance-related topics, for example, the implementation and operation of whistleblower systems, and obviously with respect to new laws and regulations, for example, also the new German Supply Chain Act. So we can go to the next slide, please. During the last few minutes, Bernd told us a lot about the current developments in the local implementation of the EU Whistleblower Directive. But the question is, what does it really mean in practice, especially for corporate groups? As Bernd already told us, according to the current status, it would be possible under certain circumstances in the German law to have a centralized solution in place. In this case, another group company, for example, the parent company, could act as a third party, but the centralized unit has to be independent, impartial, and act confidential. In general, there exist two approaches, the centralized whistleblowing system and the decentralized one. A decentralized whistleblowing system would mean that each legal entity implements and also operates an independent whistleblowing system, such as an IT system. There are some challenges which could arise from this approach. For example, it could end up in higher cost because you maybe have several and maybe different systems which have to be maintained. And furthermore, you will need more personnel which have to be trained in the different systems and approaches. A point which becomes more and more important nowadays, not only for the whistleblowing system, is the reporting of information on a corporate group level. And in a decentralized approach, this might cause challenges in standardized and in efficient reporting lines and processes. There can be issues arise from different, for example, categorization of the hints and also the different handling of the hints. And this could further lead to problems in the collection, but also in the processing of important group KPIs which have to be reported. Under certain circumstances, it might be further necessary for the parent or the group company to take action in a case because due to a potential liability of the group. And in this case, the group needs all relevant information in time to meet, for example, potential deadlines and to be able to implement necessary steps. In contrast to this, a centralized whistleblowing system, each legal entity offers an own entry channel or in an IT system an entry mask in the system and bears the final responsibility for the process, but the hints handling can be centrally operated. Also in this approach, there might be some challenges which a company has to face. For example, the acceptance of a centralized approach might be lower depending on the countries you're operating in. The focus of the law and the regulations is to protect the whistleblower, and he or she has to feel protected from any kind of retaliation, and this is the main focus of this. Besides that, it is also important, and Bernd also mentioned it, you have to be aware of the different national laws depending on the countries your company is operating in or the subsidiaries. And therefore, you have to ensure that all the relevant national laws and regulations are taken into consideration. So there might be the case when you have a centralized solution or approach that you need a decentralized approach in one specific country because the national law does not allow a centralized approach. While using a centralized approach, it should also be ensured that the appropriate labor but also data privacy laws used. To sum up, both approaches require not only very company-specific but also country-specific considerations because there does not exist these one-size-fits-all solution. On the next slide, I would like to give you a brief overview of considerations, how to find the appropriate approach for your specific company or group. Overall, you should do a status quo analysis of different aspects in your company. So you should have a look at your existing and current compliance management system and ask the question, for example, will the whistleblowing system be part of a larger structure? Maybe there is already an independent and centrally established compliance function which can be used under certain circumstances in a centralized approach. The second point is the corporate governance. So how is the company's culture? Companies which already have a variety of group-wide processes might have a greater acceptance of a centrally operated whistleblowing system than corporates with subsidiaries or entities which are operating very autonomously in many ways. Furthermore, this point is also very important, and we already mentioned it, is the international presence. So are there any critical markets, regions, or countries where your company is operating? And do you already have analyzed and considered all the local legislations which have to be taken into consideration? The fourth point, you should also have a look on further laws and regulations, such as current developments in the Supply Chains Act. This could also be considered in this point in time. So will your system be open for suppliers and third parties in accordance to the current Supply Chain Act as well? An aspect which is not only relevant, for example, for the Supply Chain Act, but also with regard to other hot topics in the ESG area, is the increasing importance of reporting relevant group KPIs. Therefore, you should have a look at your current compliance reporting situation in the company and should have a look which approaches are already implemented, which information is already reported, and the challenges have to be identified. The reporting of group KPIs resulting from information out of the whistleblowing system take an increasing part in the new area of ESG reporting from group company. The next slide shows you some examples of these reportings from DAX 40 companies in Germany. And examples for the reported KPIs could be, for example, the number of whistleblower concerns escalated to group compliance, which is then separated, for example, by the type of concern or if the hints are reported anonymized or not. The KPIs and the information you are using as a group can differ from company to company, but they all have one thing in common, that is that the categorization of the hints according to the respective entity and the relevant topics plays an important role in the reporting process and should be considered in your whistleblowing approach. With a view to current ESG topics and the requirements of the large range of laws and regulations, such as, for example, the Supply Chain Act, it makes even more sense to look very closely when you're implementing and operating the whistleblowing system, what information is needed from the whistleblower system and which information has to be reported on group level. Regardless of which approach is right for your organization or fits best, there are generally some success factors which are essential for an effective whistleblowing system. Based on our project experience, we identified a short list of success factors on the next slide, and we separated it in some organizational considerations as well as topics regarding the implementation and operation of whistleblowing systems. I don't want to go through all of them, but I would like to highlight some of them. So in the organizational part, it is very important that you have very clear definitions of roles, responsibilities, and the scope of the whistleblower system. So everybody who has a responsible in the process should know who is responsible for what or which process step, and maybe there are some deadlines you have to consider, etc. So you can implement guidelines, working instructions, or responsibility matrices to let everybody know who's responsible for what. Furthermore, you have to be compliant with so-called notification or approval obligations during the entire process. This means that you have to identify but also involve the relevant stakeholders in time. So for example, the Works Council or the HR department or data protection department, but there could also be some more. Last but not least, during the implementation and operation of a whistleblower system, it is advisable to check the efficiency and the effectiveness of your whistleblowing system on a regular basis. You can use, for example, a regular monitoring process, the reporting of statistics. You can use independent audits or a root cause analysis, which results in lessons learned. And everything should ensure that you have a continuous development and improvement of the entire whistleblowing system. As I mentioned before, there are several aspects regarding the labor law and data privacy law, which have to be kept in mind while selecting the right approach for your company. And therefore, my colleague Andreas will now go into detail regarding the labor law aspects.
Yeah, thank you very much, Daniela. My name is Andreas Brucksch from KPMG Law in Germany. I'm an employment law expert, and I'm currently involved in many projects to implement whistleblower systems. In the next few minutes, I will give you, as Mrs. Scharf has already mentioned, a brief overview of important labor law aspects regarding a whistleblower system within a corporate group. And from a labor law point of view, the implementation of a whistleblower system can trigger participation rights of an employee representation if such a representation exists within a corporate group. Such rights actually exist in many European countries, for example, in Germany, Austria, France, Spain, Poland, and Portugal. In Germany, the relevant Works Council must in principle be involved during the implementation if the implementation or use of the whistleblower system may affect issues relating to the order of the operation and the behavior of employees, or in the case of a digital whistleblowing system, if this system is suitable as a technical instrument for monitoring the behavior or performance of employees. Insofar as such a participation right exists in the concrete situation, a corresponding works agreement would have to be concluded with the Works Council prior the whistleblowing system can go live. For the implementation within a group, it is also important to involve the relevant Works Council body. Depending on the circumstances, local Works Councils, general Works Councils, or the group Works Council may be responsible. Labor law issues also arise in the design of a decentralized whistleblowing system in line with the EU Commission's view, since the group companies concerned must at least also be in a position to handle the case management on their own and under their own responsibility the question arises as to how employees from other group companies, for example, from a central unit of the parent company, can also be deployed for such a decentralized case management. According to the position of the EU Commission, such a consideration must ensure that the decision-making authority regarding case management and the measures to be taken as a result remains with the company concerned at all times. This could imply that the company concerned must be given a right to issue instructions to the employee with regard to the performance of the activity. A possible approach for this may be a type of a personal secondment from a central unit to the group company concerned in the form of a matrix employment relationship. However, it would be important to ensure that the confidentiality in case management and independence can be guaranteed, and that conflicts of interest with regard to the seconded employee are excluded. Furthermore, from a labor law point of view, it is generally important to check whether the concerned case management employees need to be separately obligated to confidentiality and secrecy, as well as to check the employment contracts for the need to adjust them with regard to the agreed tasks. With that, I finished my remarks on the aspect of labor law and will hand over to my colleague, Mrs. Ariane Loof.
Hello, I'm Ariane Loof and a lawyer on data protection law at KPMG Law, working from Berlin office. And I will now give you a short overview over for the data protection aspects of centralization on whistleblowing systems. And so we can go to the next, no, this is the right slide, sorry. So I will give you some information on what is required for centralization of a whistleblowing system and what is required for the cross-border data transfer within the group, for the what results has the matrix structure and which requirements, and how our data subject rights are covered best within the centralization of a whistleblowing system. So centralizing the whistleblowing system and or case management within the group requires, from a data protection view, at first the assignment of the respective tasks to the selected entity which will operate the whistleblowing system and or the case management. At second, legal justification of data transfer, and at third, data transfer regulations between the participating entities. The assignment of the tasks is usually done through intercompany agreements between the participating entities. The national whistleblowing law might contain a legal justification for the intergroup data transfer, but otherwise, if it does not, the data transfer shall be permitted in the legitimate interest of the group companies. Suitable data transfer regulations are binding corporate rules or joint controllership agreements and/or joint controllership agreements. The cross-border transfer within the group from an entity within the European Union or European Economic Area to a third country requires special guarantees to ensure an adequate level of data protection at the data importer. For 14 countries outside the European Union, European Economic Area, the European Commission assessed the data protection standard and evaluated it as adequate to the level within the European Union, European Economic Area. And the data transfer to those countries does not require additional regulations. But for the other third countries, the data protection standard must be established by intergroup regulations, such as officially approved binding corporate rules or individual contractual standard contractual clauses. And in addition, after the decision of the European Court of Justice on Schrems II, a transfer impact assessment might be necessary. Working in a matrix structure means that group companies the employees of group companies work together cross company and cross border. And therefore, if employees of different group companies work together across companies, this must be also regulated under labor law and data protection law. The group companies involved are usually joint data controllers for employee data in the matrix structure. However, there are no changes for the data from the reports, the entity affected by the report, and if applicable, a centrally determined entity remain responsible for the data from the reports. And the data subject rights, the rights of the data subjects must be guaranteed both to the employees working in the whistleblowing system and are covered by or are affected by the report, and to other persons covered by report. In particular, data protection information must be provided, and access request must be responded. General information on the whistleblowing system and case management procedure must be provided to all parties involved. This is usually done in the internet for external persons and on the intranet for employees. And in addition, information must be provided on the processing of individual reports, but this information and the response to access requests might be suspended under national data protection law for as long as information or disclosure would conflict with the purpose of the investigation. And that was a brief overview of the data protection issues by centralizing whistleblowing system, and I will hand over to Eqs.
Ariane, thank you very much. And also thanks to Daniela, Andreas, and Bernd for this first input. I think we can say and we see it remains complicated. Even if you have done a great job getting some structure, some clarity into this. Nevertheless, there is a number of questions that already came in via the chat. Before we continue, I would just maybe pick two questions now, and we can then look at the other questions in the Q&A at the end of the webinar. So, if I could raise the following question that came in from the participants, what would actually be your recommendation in terms of different transpositions of the directive? You had it on one of the slides where we could see that some countries are rather looking to centralized, others are looking to decentralized approaches. And I think question for especially internationally working groups is always, what do we do with such a situation? And even more, let me add this to the question, what actually determines my obligation? So does it depend on where I as a company am headquartered? So if I'm a French company, and then have legal entities in 3 of the member states, or is it depending on where legal entities are located? So this is something that obviously, is a sorrow for many of the participants of the webinar. So any input to this?
May I take over this preliminary? Yes, that is absolutely the topic. And the question, if I take it, the last question, the headquarter question, that is not relevant. As you know, that is a legal entity view on the requirements. That means, in principle, legal entities have to fulfill the requirements of the respective national law, and the EU directive is constructed not in a group view like it is in the trust law the case, but on the legal entity level the case. That means each legal entity must fulfill the requirements given by the respective laws. And if you have subsidiaries in many countries, and you should use a most flexible solution, we recommend IT-based solution where you can fulfill all the respective national requirements. That is the recommendation if you are an international group company, to look at a system which covers all the possible different requirements. It is so that all companies themselves, there is a rest of responsibility in any case. And you need in any case a certain kind of decentralized approach. That means just one centralized solution with no concerning, not concerning the subsidiary at all is not possible. That is a minimum decentralization. Even if you say a group company, the third party, you have always the requirements with the subsidiary. And therefore, if you have, if you want to organize centrally, you should set up a system which is manageable for subsidiaries and for the group as a centralized system. That is a recommendation that I saw. There was a question about Spain, and in the draft law we have Article 11, and here we have a similar situation like I described it for Germany. I think this was the question for Spain. And yes, we have also an overview over the situation in all the other 27 states, how it is transposed, or the situation at the moment in the white paper of KPMG, and I think also in the white paper then next week of Eqs.
Thank you very much, Bernd. I would actually say let's quickly continue with the presentation. So after we've taken a look at the, let's say, legislative situation, I will just give a quick introduction on how technical solutions could support these requirements we're looking at, and then we will take up the other questions in the end in the Q&A session. So let me just change slides. So you should now be able, hopefully, to see the About Eqs Group slide. Just a quick intro, because looking at the list of participants, I can see that we're having valued customers from the Eqs side, from the God Ethics side, from the Business Keeper side, and just to make sure that everybody is aligned and understands what Eqs Group today is. As of today, we've incorporated and consolidated these different brands into Eqs Group, and serving more than 2,000 customers worldwide, clearly being the market-leading provider for whistleblowing and case management solutions in Europe and in the EU. So this is, don't be surprised. So if you're from the Business Keeper side, for example, don't be surprised to see screenshots that would show the Eqs integrity line. But what I will explain is actually true for each of our solutions. So we've already heard quite a lot on the requirements for the corporate group. So legal entities that have to handle the obligation of offering a whistleblowing channel and taking care of the investigation. And we also understand that there's a number of different regulations from country to country. And what Bernd just explained is a purely central system without looking at the legal entities will not be sufficient. That's a very short version. So what will you need to do to comply with the directive, or to at least move into the right direction? While, and this is also related to some of the questions we got, we are still in a situation where we, I think, have, as of today, just 9 countries that have transposed, which leaves 18 countries where we have no national legislation yet. And I think still within these 18, there's 5 or 6 that have not even published any draft of the legislation. Yeah? So it's important to understand that we're always looking on a, let's say, country-by-country level, and we have more clarity where we have a national legislation and we have at least an idea where we see drafts being discussed, and we have no idea for some of the countries, to be very open and honest. All right, so possible solutions for corporate groups that we can support from a technical perspective. I think there's basically three approaches, and it depends, that was said before already. So if you have an established centralized system, you might want to adopt it by kind of a company/legal entity selection that would allow whistleblowers to, from a technical perspective, use the central system, but decide to make an informed decision to report to the legal entity. And with such a selection, you would enable the system to, for example, route a certain report that is made, a whistleblowing report that is made to the people taking care of the investigations that might be located or co-located at the respective legal entity. So this is kind of a smart and easy approach to move in this direction. And in addition to this, there is larger options that you could choose. One could be having kind of a centralized case management, and investigation management in the background, but providing different front ends for legal entities so that you demonstrate to the people in the country employed by the legal entity that they have kind of their own and legal entity related reporting channel. And then clearly one option could also be to implement a fully separate system from a technical perspective for each of your legal entities larger than 250 employees. So this might be the option to choose when you want to have no risk at all and you don't care about how much it might cost. Is this what we would recommend? One of the questions we can probably discuss in the Q&A. And by the way, because there was a question if the slides would be shared, so the slides from the colleagues at KPMG as well as these slides from Eqs, we will share them on request. Just drop an email to me after the webinar and we will take that we get in touch. And then you also find some illustrations how this would actually work, so the options that we've seen on the slide before. But with regard to the time, I would actually think let's rather look at some of the questions that came in and discuss them, because this will provide for sure some additional value for you. So let me just move a little bit further and then skip this, and maybe in the meantime already take up some questions. So one of the questions that obviously is important for many of the participants is, how do I behave in the right way if I have a law, for example, as in the German draft, that seems to indicate that a central system would be fine to be used, while the EU directive and the statements of the EU Commission do indicate that this might not be acceptable. And connected to this, there was a question asking if we have any idea about potential fines, right? So if someone would rely on the German legislation, say, hey, we continue to run our central system and we think it's sufficient, and later on it turns out that the Commission's view is correct and they say it's not sufficient, what will happen? Will I be fined? If yes, how will I be fined? Anything that you can say about this, Bernd?
Absolutely, and I can also hand over. However, yeah, perhaps Andreas, do you want to take over, or shall I? Andreas, perhaps he doesn't. Yes, then I take over, and yes, it is so. That is the question. You know, we have the directive, and the position of the EU was made after the directive was in force. That means you cannot change a law afterwards. Yeah, we have the directive and the interpretation and the consideration points of the directive, and these are decisive. However, the EU Commission has a position to challenge national laws by a violation procedure against the national state. However, it is a directive. A directive is in principle not directly applicable to companies, for example, if they are not state-owned companies. So only the national laws are applicable, and these national laws are relevant for the respective company who decides it. And only, and that is the next point, only the sanctions foreseen are national sanctions. That means if it should not be in line with the EU position, you do not need to pay fines, yeah, because the national law says it is okay what you are doing, and only that is fined what is not in accordance with the national law. Yeah, so it is no direct fines contained in the directive. Yeah, so what might be is that the national lawmaker is perhaps be forced to change the law, and then he will have to change the law, and then there are new legal situation, and the companies can then adjust their systems according to the new legal situation. However, as the draft in Germany is formulated, we are of good mood that this will be in line with the EU directive.
Ben, thank you very much. So, summarizing what you just said, my understanding, and correct me if this is wrong, is if you are a German company, you need to comply to the German legislation. If the German legislation turns out to be not in line with the EU directive, so the EU regulation, then there is no direct impact from the EU level to the company, right? Because they needed to comply with the German legislation. And this is the same for a French company in French legislation, and so on and so on. So no direct fines might be here, but the German lawmakers might need to adjust their legislation depending on what the Commission's perspective might be. Interesting.
That is impressive.
Yeah, just go ahead, please.
No, that is very well summarized. Yeah.
Okay, thank you for this. Then one of the questions that also came up in the chat was, is there an overview on the different legislation and the state of transposition? Bernd already mentioned it. There's a great paper from KPMG. Again, on request, this can be shared, and this will cover all the 27 member states and also include information what the current either status or plans are in terms of centralized or decentralized. Yeah, so this is quite a good guidance document. In cases, so another question, in cases where within a group, investigation might be consolidated and legal entities might make use of kind of a central function or might join forces, would you recommend service level agreements between the entities to cover this and describe what is being done?
Absolutely, and perhaps Ariane may lay out the labor law and data privacy law aspects in this respect.
Sorry, I was on mute. On the centralization of the whistleblowing system within the group.
Exactly. Yeah. The question. Yeah. On the centralization and of the group. With regard to the data privacy requirements and with regard to the labor law requirements.
So, as already outlined, the centralization of whistleblowing system also under German law, requires the assignment of a task to an entity which must be determined by the group, and an intergroup company agreement must be concluded assigning the task to the selected entity, and then the data transfer must be covered by a joint controllership agreement, and data protection standards should be established also in a group policy or in binding corporate rules. If entities outside the European Union are involved, then you need to cover you need to ensure, the companies need to ensure an adequate data protection level at the data importer in the third country. This can be solved also with binding corporate rules, or if not possible, because binding corporate rules require the approval by a data protection authority. If that is not possible, or needs is too complicated, or it's, makes too much effort on the group, then this can be also solved by standard contractual clauses. But keeping in mind that the European Court of Justice requires now for third countries without an adequacy decision by the European Commission that the data protection level in the importer country must be assessed and evaluated with a transfer impact assessment. So that's from a data protection view, the requirements is outlined, and from labor law view, the centralization issues some amendments of might issue some amendments of the employment contracts if employees from different entities work together in combined teams across the companies and maybe across the borders. Then you need to regulate this in the employment contracts and give some instructions, of course, to the employees how to handle the reports in company policies, and where entities have established some employee representatives, you might to involve those employee representatives as well. In Germany, a whistleblowing system, operating a whistleblowing system needs the approval of the German Works Council.
Absolutely, and so it's not just a simple service level agreement like you know it from perhaps transfer pricing requirements simply, but you need the service level agreement and cover all the further aspects Ariane laid out at the moment.
Thank you very much. So with regards to the time, I think we probably take 2 short questions at the end. So trying to make it very concrete, and also looking back to the poll question and the result we saw. So 55% having a centralized system. All those already running a centralized system ask themselves, would it be enough if I include an option into the centralized system so that a potential whistleblower could indicate that he or she wants to report to his or her legal entity, for example, with kind of a drop-down list saying, I want to report to legal entity 1 in France. That's part A of the question. And then part B is the investigation, the case handling in the background. Would you think it's sufficient if you have central case managers still handling it, or does there need to be a case handling person in this legal entity? That's a 2 very, very often asked questions that maybe seek an answer from most participants.
Yeah, short answer due to the time. First, yes, that is necessary, but it is not sufficient. centralized system and have just a drop down. That is necessary, absolutely, but it is not sufficient to do because we have at least a minimum of decentralized solution. So to implement this also, that's for the first question. Yes, necessary, but not sufficient. And if you have the situation like we have it in Germany, you have a third party who can use like about a service level agreement. It is possible that this third party conducts internal investigation on your behalf, but at the end, the group company always is responsible, and you have to have one, of course, according to this responsibility, who is in person responsibility for the case management. But you can outsource it in practical doing via a service level agreement if it comes to law, as it is in Germany.
Thank you very much, Bernd. Also thanks once again to Daniela, Ariane, and Andreas for participating and providing your knowledge and your expertise. Let's end up for today. Thank you very much for participating in today's webinar. I do not want to end it without a very few comments. So first one, next week on Thursday, 19th of May, we will have the next webinar together with KPMG and Eqs. Bernd already mentioned it earlier. This will look at the transposition in the member states. It's part 2, so we did part 1 a few weeks ago already. So we will focus on a few other countries this time, and you're all happily invited to participate. I think it will keep us busy for still the next weeks and months and maybe years to look at all the aspects around the EU directive. Once again, if you're interested in either the presentation slides from today or the great paper that KPMG created looking at the national legislations and draft laws so far, just drop an email to me. If you're interested to speak one of the experts from KPMG, just note it in the email, and I'm happy to connect you to Bernd and the team, because I clearly understand that there are many more questions than we had answers just today. And what we will probably offer also, but information will follow to all participants, is kind of an Ask Me Anything session. We did this after another webinar last time to take up some of the questions that were left open, but we'll discuss this internally and inform you. So enjoy the weather, nice at least here in Munich today, and have a great day, have a great week, and take care of yourself. Thank you, bye-bye.
Thank you very much, bye-bye.